Is it on YouTube?
It is.
All right. All right, we're about to start the next hearing on the September 11th, 2020 bond hearing calendar. Again, I'm Judge Brown, Richard Brown, sitting by designation as Superior Court Judge for the purpose of determining Superior Court bonds. Court is calling the case of State of Georgia versus Jameer Turner. There are 6 charges. They are as follows: armed robbery, case 2020 CW 51871, aggravated assault 51872. I'm sorry, just mistake. Let me start again. Armed robbery 2020 CW 51871, participation in criminal gang activity 51872, aggravated assault 51873. Second count of participation in criminal gang activity 51874, possession of a weapon during the commission of a crime 51875, and a third count of participation in criminal gang activity 51876. The state is represented by Assistant District Attorney Cheryl Freeman, and Mr. Turner is represented by Assistant Public Defender Leah Abbasi. All parties have announced ready to proceed. This is the defense's motion, so Attorney Abbasi, you may proceed.
Thank you, Your Honor. Judge, Your Honor, Mr. Turner is here before you. He is 19 years old and he has no criminal history here before this court. He was arrested back on April 24th of 2020. There was an incident regarding an armed robbery. Police were called. I do not believe he was identified as anyone having a gun or actually physically taking part in the robbery. My understanding is he was identified by the victim looking at his Instagram page and saying that that is one of the people who he believes was involved, but not that he necessarily saw my client. So I don't believe the connection to this crime is particularly strong. As I've said, I just have the initial police reports and it's a bit difficult to tell. It's an incident which alleges there were multiple young men involved and everything is he, without specifying in particular whom it's referring to. With that said, my client, as I said, is 19 years old, was going to Pebblebrook High School. Now, because of the pandemic, would be going online. His father is here and present for this hearing, Mr. Lamar Turner. My client had been working at Popeyes at the time of this incident and living with
I'm sorry, can you go just a little bit slower?
Oh, I'm sorry.
The father, what's the father's name?
Lamar Turner.
All right, and then after that, I have everything from that point. If you could just go a little bit slower, thank you.
Sure. My client had been working at Popeyes prior to this incident. However, if released on bond, he would be able to work with his father. His father works in construction. So his father would be able to both supervise him while he was living with him at home and during the day, I guess, providing him with a job. And because school would be online, he would also be able to supervise that aspect of his life. Mr. Turner has been very involved with this case.
Just a little bit slower.
Sorry, slow is relative for me.
I know. I'm from Atlanta, so I listen slow and I talk slow, but I'm not holding against you. I just want to take a few notes. Go ahead.
Mr. Turner has been very involved with this case from the start, in touch with my office regularly, able to provide documentation. We were able to confirm that he had been working with Popeyes. That was a Mableton location. I believe with Mr. Turner providing the living arrangement and with Mr. Jameer Turner's lack of criminal history, he is a good candidate for a bond. He has nowhere that he would be able to go. Mr. Lamar Turner could testify to his connections to the community. Certainly has no means by which to flee. My client does not know the alleged victim in this crime. And as I've said, I don't believe the victim knows him either, but had pointed him out on some social media forums. So with that, Judge, we are asking that a bond be set for him. He has been in more than 90 days. I understand that the clocks have been told as far as 90 days and when he would be entitled to a bond. With that said, Mr. Turner has been in since April, and we have no projection of when he will be indicted and how long he simply would have to sit. So with that in mind, and the fact that we don't believe he's a flight risk or any other danger to the community, we are asking he be set a bond not to exceed $50,000.
Thank you. I hear from the state.
Yes, Your Honor, I didn't know, Mr. Bossy, were you calling the father as witness or?
I certainly can. I didn't know if the judge wanted to have specific questions to address with him. Judge, how would you like me to proceed? Would you like me to call him as a witness or stand on what has been proffered?
Well, it's your case, so if you want to call him.
All right, I'll
questions.
Go ahead and call Mr. Turner. Could you please raise your right hand?
All right.
Do you solemnly swear or affirm that the testimony you give this court will be truthful?
Yes.
All right, could you speak up for me and please state and spell your name for the record?
Lamar Turner, Lamar Turner.
And Mr. Turner, where do you reside?
Mableton, Georgia.
Okay, and how long have you lived there?
About 5 years.
Okay, and your son, Mr. Jameer Turner, does he reside with you?
Yes.
If he is released, is he able to reside with you?
Yes.
Okay, and are you present in the home on a daily basis?
Yes. Mm-hmm. Yes, ma'am.
Is there any reason you would not be able to ensure that he's able to attend future court dates?
No, I would make sure that he would be there on time.
And do you understand that if this court sets conditions such as a curfew or other things like that, that your son would be bound to those conditions?
Yes, ma'am.
Okay. How long has your son lived with you or in the Atlanta area?
Here in Mableton, he lived here for about a year.
Okay. And in the Atlanta area, not necessarily with you?
Yes, ma'am.
Sorry,
Okay.
I'm sorry to interrupt. What's the answer to the question of how long has he lived with the father?
Oh, he lived here at this address with me for like a year.
What year was that?
Last year, I said up until he got into this trouble he's in.
He was living with you at the time of his arrest?
Yes, sir.
All right, Attorney Bossy, you may continue.
Yes, and prior to that, where was he residing?
With his mom.
And what area was that in?
Gwinnett County.
Okay, so still the metro Atlanta area. Is that correct?
Yes, ma'am.
Okay. I don't believe I have any other questions for you.
All right, Attorney Freeman, any questions of this witness?
Just briefly, good morning, Mr. Turner. My name is Cheryl Freeman. I'm with the Clayton County DA's office. Question for you. Mr. Bossy had indicated that Jameer Turner, he attends Pebblebrook High School.
Yes, ma'am.
Is that where he was attending before he was arrested?
Yes, ma'am.
How long had he been attending Pebblebrook?
He was just enrolled. He was about 6 months. He was into it, doing well in class, doing grades were improving. I was keeping, tabs.
Well, and that was going to be my next question. Tell me about what kind of grades was he making?
Great. B's. Matter of fact, his counselor just called me yesterday, wondering where he was, and I just, stalled him.
So before he was arrested, just so I'm clear, what were his grades?
Oh, he had B's and C's.
Okay.
Saw his last report card that he showed me. So he was doing fairly well.
Pebblebrook, is that a part of Cobb County Schools?
Yes. Matter of fact, it's just like 5 minutes from where I live, the school. I could practically throw a rock at it. So
what happened when he had a charge for a simple battery with the Cobb County Board of Education?
Yes,
Okay, has that case been resolved yet?
yes,
Was that an incident that took place at the school?
yes, ma'am.
Or he was at Pebblebrook, where did he attend school?
It was in Gwinnett. I forget the name of the high school.
Okay. Do you know if he was attending school on a regular basis there?
Yes,
What grade is he in?
12th,
I didn't hear you.
12th, I'm sorry.
Well, okay. Now, and the reason I'm asking you this, Mr. Turner, because his criminal history, he doesn't have a whole lot, but he also has something that happened with Gwinnett County School System in 2017. And that was an aggravated battery. Do you know if that case has been resolved?
Yes, that's been taken care of. Been resolved.
And that happened when Jameer was residing with his mother?
Exactly. Yes, ma'am.
Okay. Ms. Abbasi indicated that you work in construction, is that right?
Yes, ma'am.
If Jameer was granted a bond and was living with you, would anyone be at the home to supervise him while you were out at work?
He would be working with me. I told him that several times on the phone, been talking to him. He'll be working with me during the day.
Or you have to speak louder.
He will be working with me during the day. Our work's starting to pick up, back up now. It was slow. It's starting to pick up now, so be perfect timing.
Well, I guess, Mr. Turner, one of my concerns is, well, how would he attend school if he's out working during the day, if that's when school's supposed to be taking place?
Well, he's doing it online. I imagine he has a laptop. I have a laptop for him, and he could just, during the work period, he could just sit over in the corner on the laptop and do what he needs to do for his schooling.
Your Honor, that's all I have.
Okay, Mr. Turner, I have some questions. Who else lives with you?
Just me.
Okay. And you said that Mr. Jameer was living with you at the time of his arrest. When did he first come to live with you in this most recent time?
I want to say last year, probably beginning of the summer.
Summer of 2019.
Yes, sir.
So let's talk about when school started in the fall of 2019 up until his arrest. Was he home by himself while you were working? I mean, he went to school in the daytime and then you worked in the daytime and you all would be there in the evening together?
Yes, sir. I would drop him off in the mornings on my way out. I would drop him. Like I said, the school is just literally 5 minutes from where I live. So I would just drop him off and I'll go to work from there.
What time do you normally get home in the evening?
It varies from, sometimes I'm here at 3, sometimes 5. Depends on my job load, workload.
And so when you're not there, he's there by himself?
Yes, sir.
So this simple battery in Cobb County, when he was living with you in 2019,
In 2020, Your Honor.
was 2020?
Yes, in January.
Did your son get arrested on that?
No, it was just a altercation.
That's a yes, that's a yes or no. That's a yes or no. Did he get arrested on that case?
He, I had to take him to the courts
No,
and turn
sir,
himself
sir,
in.
sir, listen carefully. Yes or no, do you know if he got arrested? Yes, no, or I don't know.
No, sir, not at the time.
I
He
didn't
did
ask you
not.
about a particular time. I said, did he?
No, he didn't.
So to your knowledge, he never got arrested on that charge.
No,
Okay, now what did you want to explain about it?
I was going to explain, and not at the time. I went up to the school and they showed me videos of what happened. And later on, probably a couple of days later, I did have to take him to Cobb County to turn himself in.
And at that time, he got arrested.
A couple of days later, I turned him in at the
Okay.
sheriff's
I don't know
office.
why you tried to avoid or evade that question. It was real simple.
Oh,
But
yes,
anyway,
sir, he did get arrested, but not
okay, thank you, sir. Do you know what the final disposition of that case was?
Actually, I bonded him out of there, so matter of fact, they called me the other day and asked, and I told them
Okay.
he's still in the Clayton County Jail,
Okay.
so it's still we're just
Pending.
waiting.
Okay. Do you know that that involved a student or a teacher?
It was a student.
All right, thank you. Are you familiar with the incident in 2017 regarding aggravated battery in Gwinnett County?
Yes, sir.
Do you know what the status of that case is or was?
It's been resolved. He's been taken care of.
Well, how was it resolved to your knowledge?
I think he put him in some class or a 6-month program, and he made it through that. And
Do you know if the charge was dismissed or first offender or probation? Do you know? You might not.
that I do not know, sir.
Okay, all right, no problem. I'm sure state will advise. All right. All right, that's all I have for now of Mr. Turner, the father. However, I might have some more questions after the state has a chance to present. Anything else from you, Attorney Abbasi?
No, Your Honor.
All right, Attorney Freeman.
Thank you, Your Honor. And I'll start the aggravated battery. The GCIC I have still shows it open. So I'm not sure of the final resolution or if this young man is, if it's still on probation, or I'm not showing that it's ended. I'll say that. And as well as the simple battery out of Cobb County is still showing open. And those are the only things on his history, which, certainly is a concern of the state that the incidents both are related to where he was enrolled in school. One was Gwinnett County school system, and that was when he was residing with his mother. And then the second offense in Cobb County, where he was living with his father. And then we have the armed robbery today. And I heard what Ms. Abbasi said. According to the information that I have, what Detective Fleming indicated was that the victim positively identified Jameer Turner from a lineup and stated that he was the shooter and he was the one that fired 5 to 8 shots at him while telling the other people who were there to check his pockets. And I know Ms. Abbasi did mention social media. The juvenile was able to use social media to help the detectives locate the individual's correct name. He knew him. I guess what they found him under a nickname or his Instagram name, And when they found his Instagram page, that's when it was discovered that he was a member or associate of the 59 Brims Blood criminal street gang, which is why he's charged with gang activity. And additionally, Your Honor, it is, and this of course was in the warrant, that when the detective interviewed this young man, he indicated that this happened because the victim, who was a member of Bounty Hunter Blood, was not representing properly, so he felt he needed to rob him. That's all information in the warrant, Your Honor.
You're saying that's a statement according to the detective?
Yes,
That statement that came from Jameer Turner?
Yes, Your Honor.
Does it indicate whether that was videotaped?
It doesn't indicate what I have. I do know that the detective's file is very large, and I don't have that in front of me.
I see. Okay.
We have been in contact with the mother of the victim, because the victim was a juvenile. She has indicated to us that she still has safety concerns for her son. And I read somewhere in some of the information I have that it may have been one of the other parties involved, that someone was or attended Charles Drew, but I'm not sure if it was this young man or not. Yes, well, the victim indicated that two of the subjects who were there attended Charles Drew High School. So I'm not sure, like, again, if Mr. Jameer Turner was one of those individuals. And so, Your Honor, and we realize this young man has been in our jail, according to my record, since April 24th, I believe. And I think we've had a bond hearing before. I do remember Mr. Turner testifying before regarding his son. The state still has the same concerns as we've had, the safety concerns, the stability of Jameer. When I asked his father about school for him, he indicated that he could take his laptop and he can be up in the corner while at a construction site or whatever it may be. But I don't know what the situation is at Pebblebrook or in Cobb County Schools. I don't know if it's a situation where it follows the normal school day, if Mr. Turner has to, if he has a class from 9 to 10, if he has to be logged on at that time. I don't know that, but the stability regarding his school it does not seem to be there. And so the state at this time, and Mr. Bias and I could not come up with a consent bond. This case has been assigned to ADA Christopher Sperry, who is one of our gang experts or gang prosecutors. And so at this time, the state cannot consent to a bond regarding Mr. Turner. If the court is inclined to grant a bond, given that he has been in since April 24, we are asking for a very high bond with a GPS as well as a curfew in this particular case. And we would ask for no less than $175 regarding a bond on Mr. Turner.
Attorney Abbas, anything else?
Judge, unfortunately, I'm not privy to the large file that the state has. So for a number of their representations, I'm sorry, I'm not able to respond. I don't have the information. I've not been given it. I don't have anything about an aggravated battery on him.
All right, well, his father confirmed that he's charged with aggravated battery. Who's your witness? All right. And plus, you can confirm it with your own client as far as the aggravated battery. You have anything else?
No, Judge, we stand on our position. I don't think Mr. Turner is a flight risk. This court's first and foremost concern is whether he will return to court. His father has been here to assure the court that he will be able to return if he is released on bond.
Well, the court's foremost concern is the safety of the community. And given the fact that this young man has lived with the mother in Gwinnett County, has an aggravated battery charge pending in Gwinnett County, and then subsequent to that changed and started living with his father, and now has a simple battery charge pending. And then subsequent to that, he's charged with armed robbery, participating in criminal gang activity, aggravated assault, possession of a weapon, and the state has proffered that there is a police interview in which he acknowledges that he appeared that he was in a gang and he was upset with the alleged victim for not carrying out gang, not meeting certain standards. And the alleged victim positively identified Mr. Turner as the shooter who fired 5 to 8 shots and told others to check his pockets. And from his Instagram page, it further confirms the state's position that he is involved in criminal gang activity. Again, he is presumed innocent, but for the purpose of bond, that's the safety. But the stability, the court shares that same concern. He was living with the father at the time of this alleged most recent incident that he's in custody for now, and appears father totally oblivious to the fact that he may be involved in a gang. And father's trying his best, working. He's going to take the son to work with him and let him work on a laptop. At this point in time, with his Instagram page and everything, I'm not sure what's going to be going on that laptop. The court has serious concerns and denies bond, finding that he posed significant risk to committing of felonies while case is pending. The court is sensitive to the fact that we have the judicial emergency and time has been told, but this young man appears to be taking his family's kindness for weakness and has shown no total disregard for the efforts that they're making. And he appears to only be thinking about himself. If not on those first 2 cases, again, all of them, he's presumed innocent, but there's a lot of smoke wherever he is. And the court has the same concern as the state and denies bond. That would be the order of the court.
Your Honor, I'm sorry.
Go ahead.
I would like to put on the record, I believe it's going to be erroneous if this court's first and foremost concern is the seriousness of the offense under Mullinex versus State 271 Georgia 112 from 1999. The court's foremost consideration is supposed to be whether he will appear in court. It is to a lesser extent his ability to pay, the seriousness of the offense, his character, his reputation, and things like that. And if this court is weighing so heavily the allegations against him and the seriousness, I would ask that, of course, we'll eventually file another bond motion. This defendant be able to subpoena the entirety of the file to respond to the allegations against him. We certainly are able to present witnesses and make a case for whether he will appear in court or whether he's a flight risk. But without access to all of the evidence of what's being alleged for the seriousness of the offense, we really have no way to respond.
All right, well, you know the criminal procedure and you know that this is a bond hearing. You're not entitled to that at this point in time. However, the court is required to take into consideration whether the accused posed significant risk of committing other felonies while pending trial. So the court is taking all of that in consideration, and you please feel free to file whatever you need to file in order to obtain what you need and in order to make another effort to have the bond set. At this time, it's denied. Unless there's anything else, that'll conclude this hearing.
No, Your Honor, that's all.
All right.
May Mr. Turner and I be excused?
Yes, and it seems like your client wanted to say something. So, Mr. Jameer Turner, your attorney boss, will get in touch with you after speaking to your father.
I'll
Thank
talk
you.
to you next week, Mr.
All
Turner.
right.
One thing I wanted to say is, Mr. Bossy, since Sperry passed the case, I would certainly say just be in communication with Mr. Sperry, and the two of you all may be able to work something out with it. He's more familiar with it, everything than I am.
Okay, thank you.
All right. That's your last case, Attorney Bossy, correct?
It is, Judge, and will there be a written order entered?
Yes, ma'am.
Thank you, Judge.
All right. Thank you.
Sure, put your hands behind your back, face the wall when you get in that sally port right there.
All right. Mr. Turner, the father, you can sign off. Sorry, we couldn't do more than we did. But your Attorney Bossy will talk to you. You can
All right,
sign
thank
off.
you.
All
Thank
right.
you.
All right. All right, what's next, Barnes or Loach?
I think
I'm ready.
ready on Barnes.
Okay, let's, we'll need, all right, Deputy Jameson, we need Barnes next, when you get a minute.
Yes, Your Honor, he's coming up now. Barnes. Step up, say your name.
Cornell Barnes.
All right, thank you, sir. So hold 1 second, let me state for the record that this court is calling the case State of Georgia versus Pernell Alfonso Barnes. And he is charged with one count of aggravated assault. Case 2020 WA09146, criminal trespass 9148, obstructing the officer 9149, and possession of drug-related objects 9150. Mr. Barnes is represented by Assistant Public Defender Nelson Rhodes. State is represented by Assistant District Attorney Cheryl Freeman. All parties have announced ready to proceed. And Attorney Rhodes, you may.
Thank you, Your Honor. We're here on a bond motion to have a reasonable bond set for Mr. Pernell Barnes. He's been in jail since May 26, 2020. And to date, that would be 107 days on these charges with no bond, at least on the aggravated assault. As a bit of background on the case, we had a prelim on July 6th. Facts came out that this was a matter of a domestic dispute between my client, Mr. Barnes, and his long-term girlfriend, and no other witnesses were present. The knife that was allegedly used as a basis for the aggravated assault charge was found where knives are usually found, in the kitchen. It wasn't submitted to evidence. So it's my belief that this is, generally speaking, a flimsy case. But since then, since the initial incident, the alleged victim, Ms. Hughley, has signed a non-prosecution affidavit, and has not only expressed that she wants Mr. Barnes out of jail, but has vehemently worked to get him out, setting up a safety network for him once he's released on bond. Ms. Hughley has basically gotten him entered into programs run by Associated Counseling Incorporated, located in Jonesboro, where they offer a 24-week state-certified family violence intervention program with anger management classes and drug treatment included in that. And he is prepared to enroll in that as well. Ms. Hughley is also willing to participate in couples or family counseling, if that would help him in his, road to recovery. And yeah, associated counseling is in good communication with Clayton County. They would be able to inform the county if he were to miss a meeting or a class. And yeah, there's space for him there. The only small issues that associated counseling doesn't give acceptance letters unless patients or potential patients have been screened for COVID. And right now we don't have those COVID results yet. We can only kind of order those once he's released from jail. So unfortunately at this moment, I do not have an acceptance letter, but we have been in contact with associated counseling. They are willing to accept him pending a negative COVID screen. Further, the state, I think, agrees that this case is one for treatment rather than for punishment. And that's what we're trying to get him, treatment. At Superior Court, the state's offering something similar, a sentence that's suspended upon completion of a DORA-approved inpatient program. The problems with that are that, with these programs, them being inpatient and kind of being in somewhat high demand and clogged, especially during the whole COVID time, we don't know if there's going to be a bed available for him. So even if he were to be accepted into one of these programs, he might not actually be able to, go there until later. And in our last communication with one of these programs, their first estimated time that they'd have a bed available was in January. So we're just trying to get him, treated sooner and more efficiently. Second problem is that these programs are, by nature of being inpatient, it's kind of high demand and they're more expensive, and much more expensive than my client is able to actually afford. So all of these things considered, we ask for a bond set at $18,000 for the aggravated assault and $1,000 each for the criminal trespass, obstruction, and drug-related objects. We believe that those are reasonable amounts, considering that we also would add special conditions to a bond order of enrollment in a drug treatment and family violence course at associated counseling or any other reputable outpatient center. Mr. Barnes poses no significant risk of fleeing jurisdiction of the court. He's from Georgia. His entire family lives in the state, and while in Georgia, he's worked in restaurants for about 15 years. Most recently, a restaurant, TGI Fridays. We believe that he will have a job there waiting for him as well, pending release. He has plenty of ties to the community. He's participated as a mentor in the United Way's Youth for Change program. He mentors kids at the school where his 6-year-old attends. And he was a bus stop monitor, also making sure that the kids get, to their houses from school. He's also volunteered at the Covenant House. He's helped serve food at homeless shelters. So we believe that he's a great candidate for bond. Again, he's been in jail for 107 days, just missing a bond on the aggravated assault charge. But again, there were no witnesses there. We don't believe that the state has an airtight case. The only witness and the alleged victim is, had no safety concerns, certainly, and is working to get him out of jail, actively working to get him support outside of jail. And part of that is in, enrolling in these programs that we have lined up. So if Your Honor would be so inclined, again, we're asking for a bond set to the total of $21,000, which would be $18,000 for ag result, $1,000 each for criminal trespass, obstruction, and drug-related objects, with a special condition of enrollment in drug treatment or family violence course at associated counseling or any other outpatient center. That's all. Thank you.
All right, I hear from the state.
Thank you, Your Honor. I would like to say on the record, and Mr. Rose may have spoken to another 88, but I don't have anything in my file that indicates that a resolution that that's being recommended has to do with inpatient treatment. I don't have that information, so I cannot represent that to the court. What I will say is that the victim in the case wrote a statement regarding the incident, indicating that the defendant got upset because he wanted her to give him money and take him somewhere to buy drugs. She has indicated that he does have a problem. She has not one time said that this incident didn't happen. He threatened her. He put a knife to her. She was in fearful for their 6-year-old son. I guess the same son that Mr. Rose has indicated this defendant has volunteered at the school or mentored other students. I don't know, but she was concerned for her child. When she was able to flee the residence, Mr. Barnes actually deadbolted the door. And so officers nor the victim could get back in the residence. When they finally made entry, the concern was for the son because threats had been made and the victim was concerned for his safety. They were able to retrieve the son without any injuries. But the victim has since indicated that she does not have any safety concerns, but the state does have concerns given the incident, the allegations that happened. And again, the victim has not said that this didn't happen, but it does seem to stem all from a drug problem that this defendant has. And I will say he does have a bit of a history, and I'll let the court know what he has. Let's see. And it begins, let's see, in 2006, he has a theft by receiving stolen property. That was a felony in Fulton County. Looks like he had, and there was also a possession of marijuana. There was a probation violation in Clayton County, I think, for possession of marijuana. We have a disorderly conduct in 2008. It looks like we have another probation violation. There's a possession of marijuana in 2008, and that's out of Lake City. In 2008 in Fulton, there's a failure to appear for a possession of cocaine charge. In 2008, and this is out of Fulton, looks like he has a theft by receiving stolen property, a felony, entering auto.
Sorry to interrupt. How many cycles does he have?
Okay. He has 27.
Give me the last 7 and give me
Okay.
the dates, please.
In 2014, there was a failure to appear that was in Clayton County. In 2014, in Henry County, there was a possession with intent of marijuana, obstruction, as well as a driving with a suspended license. In 2018, there was a charge of a non-consensual dissemination of private images. And I believe that was in, I think that was in Minnesota, as well as in 2018, a disorderly conduct in Minnesota.
All these are convictions?
Yes, sir.
All right, you may continue.
So those were the ones from 2014
I see.
coming forward. So the state certainly does have concerns, especially in light of that he has convictions out of state as recent as 2018 and allegations of what happened. I do realize he has been in since May. And we have been in contact with the victim, and she has indicated she does not have safety concerns and that she wants Mr. Barnes to get some kind of treatment, which is certainly for, when it comes to a disposition of the case. She indicated to us that he needs help with his drug issues, and she indicated that he had been clean for years but fell off the wagon, is what she had indicated to our office. So if the court is inclined to grant a bond on the aggravated assault, We're asking at least for 40,000 on that. The criminal trespass already has a $2,000 bond, as well as the obstruction has a $2,000 bond. And for the drug-related objects, that already has a $2,000 bond also. And given what the victim has said, we would ask for no violent contact regarding a bond.
All right, Attorney Rose, anything else?
Yes, Your Honor. We just cannot make a $40,000 bond on the aggravated assault alone, and we asked for something reasonable. Again, bond is just to assure the defendant's presence in court. You know, he will be able to show up to court. He has nowhere else to go. He will be living in Morrow, Georgia. I do have a specific address if the court needs to hear it off of YouTube. And he does have a support structure here. He will have a job. You know, we are trying to get him into a program for drug treatment. And, you know, we would accept, you know, if the court, you know, puts into the bond order, you know, upon successful active enrollment or completion of a program. We mentioned associated counseling. We would be open to any program that the court might provide, so long as it is not financially taxing, because again, my client, of course, being out of work for a while is, you know, just doesn't have a lot of money on hand. So yeah, we ask that the bond be set reasonable, considering my client's means. Further, as the state has mentioned that Ms. Hughley has not stated that the incident did not happen. My position is that, well, one, she, you know, may have made a statement to the police officers at the time of the incident, but has since shown basically that she would not exactly want to testify against Mr. Barnes. You know, she signed a statement to not prosecute. So, I mean, we just, you know, considering all of that and considering, as I mentioned before, I believe the weakness in just proving beyond a reasonable doubt this aggravated assault charge with the knife as a basis where, you know, there's no real proof that a knife was used in any certain way. We asked for the aggravated assault be set at a reasonable bond that my client can afford. And again, we recommended $18,000 with special conditions, of course, that I mentioned. This is mainly a case for treatment. So we can have a special condition that includes drug rehab or family violence counseling. I believe that would be very reasonable.
Okay. All right. Well, in terms of what's reasonable, and I should be a defense attorney and a prosecutor, but it's easy to forget that when you say what's reasonable, you can not only take in finances, you have to also take in the criminal history. And the criminal history of this person is atrocious. And it shows no indication that he would follow any particular bond condition, especially in his present state, which is everybody agrees he needs treatment. But he has a record full of failure to appear and violation of probation and continuous drug usage and out of state. So to release him under those conditions without him having an in-house program, you say, a court has some concerns that it would be, it would not be really serving him well. A drug condition and problem going back as far as he's had, it appears, cannot be rectified with a family violence intervention program or outpatient program. He needs an inpatient program. And other concern the court has is, yeah, it fell off. I mean, the alleged victim is not trying to put him in jail. She just wants him to get the help. But as the state has indicated, that she is fully, she is standing on the original complaint in terms of why the police were called. And when you hear what took place of that particular incident, Dad bolted the door and made threats. So all of those kind of conditions without any treatment in place or having any assurances that once he walks out of the jail, that there would be something in place. The court has serious concerns about even whether he would flee or return to court or commit other felonies pending trial. So the court is not in a position to go against the state's recommendation. Did the state say that you're opposed to bond, or that you said you're opposed?
Judge, I said it if that I would ask for a minimum of 40,000 on the ag assault, and the other charges have 2,000. And that's only because the victim has indicated that she does not have safety concerns and that she was not opposed to a bond.
All right. Well, but for the state agreeing to that, court probably would not be inclined to set a bond, but the court will set a bond based on the district attorney's recommendation and taking into consideration the alleged victim indicating she has no safety concerns, which needs to be placed on the order for bond.
Yes, Your Honor.
So that would be the order of the court, the 40,000 and the other amounts the state just indicated. Anything else, Attorney Rhodes?
No, Your Honor.
All right. Now I'll say this: if at any time there is an in-house program that he could be from the jail to the in-house program, then the court would be open to do whatever it needs to do to make sure he gets into that program and not let bond be an obstacle. But again, I know that's going to be a real difficult thing to do, or a big challenge. But without that, the court just has serious concerns regarding the condition he's in. If he doesn't have the necessary means or treatment that he needs to get to the root level, then I think everybody is going to be taking a big risk. That'd be the order of the court. You can come back and file a motion to modify if you're able to find a program that will take him in from the jail to the program and to the residence. Thank you. I'll stand by for the order, and that'll conclude this hearing. Mr. Barnes can go back with the deputy, and I'll stand by to sign off on the order. Anything else for you, Attorney Rhodes?
No, Your Honor. And then I believe that concludes the public defender's business with the court this morning. May we be excused?
You may. Thank you. Have a good day.
Thanks, you too.
All right. We'll go straight. Unless Attorney Freeman needs a break, we'll go straight in.
Yes, if I can have about 5 minutes, Judge.
All right, court being recessed. It's 11:06 to 11:15. Thank you.